Plaintiffs are mixing and matching not just apples and oranges, but tomatoes, and it's creating this fruit salad of prejudice. And I'm not sure that Nevada Beverage is going to be able to get a fair shake here.
Nine to 27, Hunwardsen versus Affinity Lifestyles, 831-543. Counsel, feel free. Sorry, I have a question. There is. Oh, yes. Okay. I do appreciate it. Thanks so much for the heads up. Okay, so can I have counsel's appearances, please? And that is pages 9 through 27, Hunwardsen versus AffinityLifestyles.com.
Good morning, Your Honor. Eric Pepperman for Plaintiffs.
Good morning, Your Honor. Colt Dodrill, bar number 9000 for defendant Nevada Beverage.
Good morning, Your Honor. Karen Baxter on behalf of Nevada Beverage, bar number 11913.
Okay, and then remember on this.
Morning,
Morning,
Your Honor. Michael Federico on behalf of Costco.
My apologies. Sorry about that, counsel. Okay.
Good morning, Your Honor. Jason Wigg, bar number 7953 on behalf of Hannah.
Good morning, Your Honor. Elizabeth Lowell, bar number 8551 for Milwaukee Instruments.
Okay.
Morning, Jenny Sani for Affinity Lifestyles and Real Water.
Now have I taken care of everyone? Just want to make sure. Anybody else? Was that cross-check from your list of checks in? Okay. Okay, and remember on this case, there was the media request that the court did sign with regards to this case. So remember, and with regards to media requests, they can either be in person or they can be remote. They can do it within the full scope of the media request. And people, of course, more than welcome to listen in because it is a public courtroom as well. So we have motion practice. We have defendant Nevada Beverage's motion to strike plaintiff's second amended complaint, motion to sever claims against Nevada Beverage, document 109, opposition 124, reply 142, and then we also have a motion, Nevada Beverage's motion to remove from business court, document 108, opposition 125, and reply document 141. And then we have the audio visual requests from some of the parties. So any party who's on remotely who did not file the document request, the audiovisual request, we do have it from Whole Foods, Milwaukee Instruments, Terrible Herbs, Costco, and AffinityLifestyles.com. Is anybody else doing an appearance that did not file a remote appearance, please, under Supreme Court rule and under the administrative order?
Your Honor, Jason Wigg here on behalf of Hannah. I don't know if my office filed a notice or not. If not, my apologies.
How can you appear under a Supreme Court rule which requires it mandatorily, and even an administrative order 22-7, right, which has the shall language, made sure to reinstate? So, yes, I'm asking how you can appear. I'm a district court judge, right? District court judge needs to follow, and I do follow Supreme Court rules, administrative order. So I'm asking if you have any authority or basis on how you can make an appearance. Of course, anyone's more than welcome just to, be on Blue Jeans. But if you're physically making an appearance, physically either remotely or in person, and here the issue is remote, right? I'm asking you how you can do that under the Supreme Court rule and the administrative order. Is there some authority for you to be able to do so, please?
I have no idea, Your Honor.
Are you wishing to speak at all, or are you just in an observation capacity?
I filed no motion. I filed no opposition or joinder. I'm just here observing on behalf of my client, Your Honor.
People, of course, are welcome to observe. It is a public courtroom, but do remember if somebody's planning on participating in any manner or wishes it to be viewed as, quote, an appearance, right, under the rules as counsel of record, rather than just an observation, then, of course, please make sure you do read Supreme Court rule, the administrative order. And actually, the memoranda that we give to everyone also says that, right? The bold paragraph, which is the second paragraph that you had to get through in order to actually get the link for the Blue Jeans. So please do ensure that anybody needs to do that. They do need to follow that because those are mandatory rules. And so far, no one has provided this court any basis on how this court would not be required to comply with the Supreme Court rule and the administrative order. And if anyone has anything that says I don't need to, feel free to provide it to the court for its review. That being said, substantively, since you're saying you're just observing, we won't treat this as an appearance, we'll just treat this as an observing, okay? And now let's go to the motions. Seems to me that the business court motion should go first because that was going to say whether or not the court should be hearing the second motion. So the court is going to do Nevada Beverage's motion to remove from business court document 108. First, I will tell you the court's inclination is to deny that. Realistically, the EDCR, this has been treated as a business court case. It is a complex litigation, i.e., a lot of the issues cited in the opposition set forth. It falls within the scope of business court matter. Well, I appreciate it does involve some products liability if you look at all the other factors and you look at the intent of business court, and that this has been a business court case even before getting removed up to federal court and then when it came back down. So I also have to look at those timing, I have to look at the prejudice of all the other parties and the severing components as well. So that's just a court's inclination. Go ahead, counsel for movement. Go ahead, please.
Thank you, Your Honor. Good morning, Colt Dodrill for defendant Nevada Beverage. Nevada Beverage is a large player in the distribution of beverages in Clark County, but it's a small player in the cinematic universe of the real water litigation. We're in approximately a third of the cases, but only 9% of the plaintiffs are suing us. And I know that spills over the severance, the striking, and the business court all sort of feed into each other. And all Nevada Beverage really wants is fairness, being in the proper venue with properly joined plaintiffs in a properly pled complaint. And we're not sure we have that here. And I do want to start with the business court motion, which frankly we didn't anticipate in opposition. The EDCR 1.61 is pretty clear. It's been approved by the Nevada Supreme Court, and it specifically says examples of cases which are not business court matters include, but are not limited to, those for which the predominant legal issues are centered on personal injury, like the court mentioned, this is personal injury action, that's strike one. Products liability, this is a products defect case. Plaintiffs are alleging that the real water was toxic and somehow caused them personal injuries, strike two. And then claims brought by a consumer individually or representative of a class against a business. And plaintiffs here are the end product consumers of the real water, strike three. So we feel that the Nevada Supreme Court, which approved Rule 1.61, did not want personal injury matters like this in business court. None of the exceptions that plaintiffs raised in their opposition we feel have any merit. We've just been brought into this suit, and the fact that we answered in another matter and did not challenge a business court designation in a separate matter under different circumstances last year should have no bearing. There's no case law on that. There's no reference to that in the rules. And I refer the court to subpart C3, that talks about the timing of the motion. And it says specifically within 10 days of receipt of the assignment of the case to a business court judge or within 10 days of filing a responsive pleading, whichever is later. Again, the EDCRs contemplate a later filing. And so our motion is timely, and I don't see anything that limits complex matters, matters that are assigned to special masters, matters that may have a certain relationship with other cases from being limited to business court. Those cases can be filed in a general court, for lack of a better term, and there's another whole laundry list under sub B of other cases that should not be in business court, and that includes sub 17 construction defect claims, which again can be complex and need not be obviously in business court. So the court recognizes that complex matters don't have to be limited to business court, and we would ask that the court not allow not allow plaintiffs to designate personal injury cases in business court. It's just simple. We just want the rules to be followed. We think that's the best way for everyone to have the fair and just and speedy remedy.
Appreciate it. Let's deal with that one first. So that means opposition, counsel?
Your Honor, I just would point out that we did follow the rules. We followed EDCR 1.61. We filed 11 separate real water cases, all in business court, under the first part of EDCR 1.61, which provides that business court designation is proper in cases involving, quote, claims or actions arising under the UCC. Our complaints, all of them, assert claims arising under the UCC. They were properly filed. 11 of them, going back more than a year now. No other party has challenged the designation. Nevada Beverage appeared in this case more than a year ago. It appeared in another case where it filed a responsive pleading more than a year ago. Never disputed the business court designation in either case. And I would note that Nevada Beverage has still not filed a responsive pleading in this case. So under their interpretation of the rule and the timeliness, they can appear in a case, participate in the litigation for more than a year without filing responsive pleading because of a stipulation with another defendant, and then just when they decide a year later, after we've been in the same court and participating, to just file this motion, create work on our plaintiff's behalf, unnecessary expenses, unnecessary time, drafting briefs, coming down here to court, taking up the court's limited judicial resources, making other parties wait. For what? For what benefit? How is Nevada Beverage aggrieved by being in this court that it's been in for a year and it's in other cases in this court? We have a special master. Nothing would change by removing this. This appears to be improperly motivated motion to waste time, money, and distract from real work that we have to do in this case. So, Your Honor, I think your initial inclination was absolutely correct. I think you summarized our argument and positions clearly and succinctly, and we would just submit on that. Your Honor, thank you.
Counsel, do you want to point me to your second amended complaint, the provision you say that relates to the UCC, since that was brought up as saying it does not?
Yes, Your Honor.
It was saying it had different sources. Go ahead, please.
I apologize. It's the breach of warranty claim in the second amended complaint. I don't have the exact paragraph in front of me, but I reference it in the opposition.
Okay, it's okay. Bless you. Okay, you get last word, counsel. It's your motion. Go ahead, please.
Thank you, Your Honor. Again, 1.61 is clear. I'm going to focus on first the warranty claim. Breach of warranty, almost every product's liability claim would, by definition, be a breach of warranty under a strict application. And there's two parts to sub B that show that what plaintiff's counsel said is not persuasive. One is that the rule specifically says those for which the predominant legal issues are centered on. So you can't tack on a random token claim and say, hey, this shoehorns me into business court. The predominant legal issues are centered on personal injury, products liability, and consumer actions. So for them to say, well, there's a breach of warranty claim, that's disingenuous. And second, under the canons of construction, not only does the specific exceptions of sub B in sub B, and canon of construction says you're not going to interpret a court rule to render one portion superfluous. So to say you can get around sub B just by throwing in a breach of warranty claim is not sufficient and is not within the confines of Rule 1.61. Second of all, regarding my appearance in the Bonner case, and we answered that case, and as we stated in the reply, that's really a one-off case. It's the only case alleged against Nevada Beverage. It involved a retailer we didn't distribute to at that time, There's just no facts to show that we even need to be in that case. And so those challenges weren't made. Since that time, about 2 weeks after we answered Bonner, we were made a third-party defendant in this case, but we did not answer the third-party complaint against us filed by Terrible Herbst, because there were some discussions regarding amending the pleadings, amending the complaint, amending maybe the third-party complaint, and they were straightening out who needed to be there. Again, even though this case is a year old, it's still in its infancy and the parties are still being sorted out. So we had an extension, but for whatever reason, even though we answered in Bonner and said, yes, we distributed to at least some Costco stores, plaintiffs had waited a year before they brought us in here. So again, it's a little bit disingenuous to say we've sat on our laurels. We haven't, Your Honor. We've just been made a defendant in this case a little over a month ago when the second amended complaint was filed. And then since then, we've been brought into 2 other actions, but only recently. It's the first time we've ever been on the Richt case, which we mentioned in our brief, and it's the first time we've been brought into the Daisy Way case, which I don't think is before, Your Honor, but it's one of the 12 and the 4th that we've brought in. So I've not seen any case law that says if another defendant answers a complaint, it prevents us from making a challenge. If I answer a complaint in another action, it prevents me from challenging a business court designation. I'm looking at 1.61, and it says any party, not the first party, not the first 5 parties, not the parties initially joined.
Okay.
Any party, and that's what we are, and we're filing that.
Okay, we appreciate it. Well, you all agree, there was no joinders or anything on this, so I'm only looking at 1.61 with regards to the parties at issue. So EDCR 1.61, assignment of business matters, right? And I'm going to first go to C3. Any party aggrieved by the designation of a case as a business matter may seek review by the business court judge within 10 days of receipt of the assignment of the case to a business court judge. Well, it's way past that because I'm judge number 2 on this case, and I got this back in September 2021, realizing certain things were removed, stayed, all sorts of good things, but okay. So then you look at the other ones, or within 10 days of filing responsive pleading, whichever is later. Well, interestingly enough here, there's no responsive pleading, right? All parties agree?
Unless the court interprets our Rule 12 motion as a responsive pleading.
Well, Rule 12 says what Rule 12 says what Rule 12. So realistically, there's 2 ways to go. One, it's not yet ripe because there's no responsive pleading, right? It's not 10 days within a responsive pleading. So the filing, there's not been any responsive pleading. So A, it's not ripe, or B, the substantive ruling. The substantive ruling is, if the court views this as ripe, if the court were to say responsive pleading is a motion to dismiss, but remember, really it's not, but even if I were to go that route, realistically the court would deny the motion to the extent that the stipulation, and once again here there's a little bit of a challenge because you have this underlying stipulation. It's why you're getting my substantive analysis on actually ruling on it. It's A, you filed the motion, and you seem to file the motion and seem to think that the stipulation and the fact you haven't filed an answer didn't seem to preclude it, nor did anyone raise that issue in either brief. So the court's going to give you the substantive rule. The substantive would be, I would deny it as well as an alternative basis. If it is right before me, I'm denying it because, realistically, the face of the complaint, the second cause of action, falls within 1.61A2 little I. Claims or cases arising in a uniform commercial court or as to which the code will supply the rule of decision. So, realistically, well, I'm not going to say my non sequitur. You all were listening to the last hour before you all were here? The opioid litigation? Are you all contending that also shouldn't be here in business court? Because it involves products liability and sale of... Anyway, realistically, you have to look at the UCC. And you have to look at the broad interpretation of how those have been evaluated by the business court judges when issues either A, have been brought before them, or B, when the business court potentially could sua sponte look to see if something should be here in business court. These type of cases, plus you have the clear language of the second cause of action, this court can't make a determinative decision about whether or not they think the second cause of action is more important than their other causes of action or less important than their other causes of action. realistically is in the second amended complaint. It has been litigated as being the type of case that should be in business court. This particular case, now the court is looking at it and taking into account that Nevada Beverage is a specific party in this case. I'm not taking the other cases that this court has. I'm not taking the coordinated cases. I'm taking this case, okay? I'm looking at this case and what is the factors with regards to this case. It's got a separate case number and it's only coordinated for discovery. It's not consolidated, so it needs to be treated on its own. And when I really look at it, I do see that it falls within the UCC. You've got a second cause of action, so the court's going to deny it substantively. If the court were to view the fact that you're filing a motion that somehow you're waiving the concept of the fact that you didn't file a responsive pleading, or if you're viewing it that your motion to dismiss is a responsive pleading, because otherwise under Rule 11 you shouldn't have filed the motion. So I've got to give you the benefit of the doubt, right, that you filed what you thought was a proper motion, so you're treating it that way, or somehow the stipulation applies. So I've given you both the procedural and I've given you the substantive ruling. Either way, we'll look forward to seeing you here. So it is so ordered. That means counsel for the non-movements, you're preparing the order, okay? We need to get this case taken care of. So now let's go to the next concept. The next is their motion to strike the second amended complaint and to sever the claims against Nevada Beverage. And since technically those have different bases in the rules, whatever you'd like to argue with regards to that, go ahead, please.
Thank you, Your Honor. Colt Dodrill for, defendant Nevada Beverage. We're looking at this second amended complaint holistically, and I didn't do the math, but it looks like about half of it relates to allegations that took place, of facts that allegedly took place in 2020 that render these, that are completely immaterial and inflammatory as to the two plaintiffs, and there's only two plaintiffs of the 6 here that are suing my client, which kind of begs the question why they're properly joined. And I think we should maybe address the severance first. These are not the same transaction and occurrence. If I walk into a Costco in 2018 and buy 1 liter bottles of real water, that's a completely different transaction and occurrence than someone else getting home delivery real water 2 years later. Plaintiffs are mixing and matching not just apples and oranges, but tomatoes, and it's creating this fruit salad of prejudice. And I'm not sure that Nevada Beverage is going to be able to get a fair shake here. 2020 facts that plaintiffs allege in the second amended complaint, and these facts are obviously what we dispute, but we take them as they are for right now at this stage of litigation. A super bad batch of foul tasting water, dead and dying pets. Mr. Hunwardsen is not alleging that. He's 2019. Ms. Brody is 2018. They're not alleging that. None of them consumed anything remotely near the alleged super bad batch. None of them allege they have dead and dying pets. The alleged cover-up does not involve Nevada Beverage. It involves this foul-tasting water that was home delivery only in 2020, long after those two plaintiffs stopped consuming the water. Casey Aiken is an inflammatory issue in the second amended complaint. They allege he worked at a gentleman's club. I don't know how that could even remotely be relevant, but it's certainly scandalous, inflammatory, shows his moral character that wouldn't even come in under character evidence rules 48.045 of our evidence code. He was trained afterwards. Again, that was long after Mrs. Brody got sick in 2018. Mr. Hunwardsen allegedly got sick in 2019. Casey Aiken didn't even start till June of 2020. That has nothing to do with us. And 2020, we talk about transaction and occurrence. They're apples and oranges. I don't know how else to say it. Efficiency. Again, this case is in its infancy. The special master filed a status report not too long ago, saying that Real Water's in the process of uploading those documents and getting those dates. Again, the plaintiffs have just recently amended their complaint, trying to straighten out who should be in and who should be out. And that includes us, which we think we should be out on some of these for various reasons. Severing would be efficient as well, because nobody would have to file a motion for separate trial. We don't think we could get a fair trial if 2018 Ms. Brody is being tried with all this evidence about all this awful inflammatory stuff from 2020. Talk about motions in limine, redact the complaint. We wouldn't want the jury to see some of these things. I think it'd be odd if the jury couldn't look at a complaint, but that's what would have to happen here for Nevada Beverage to get a fair trial. Again, motions in limine to exclude subsequent remedial measures, character evidence, and all this other stuff that had nothing to do with it. Make perhaps limiting instructions, perhaps jury questionnaires, trying to narrow this thing down. The days, if not hours, if not days of testimony regarding what may or may not have happened in 2020. It has nothing to do with the retail plaintiffs, and it has nothing to do with anyone that allegedly got sick before 2020. And I don't see how plaintiffs could say that, hey, they're going to be prejudiced by this. We need to follow Rule 20. And so I would ask that Ms. Brody be severed out as part of our analogy, the tomato in this fruit salad. She's not even apples and oranges, because she never consumed home delivery real water, which is the issue that predominates this case. Myles Hunwardsen, he's sort of a hybrid, because he got home delivery water and some retail water, but that was in 2019. And unlike the opioid cases and the asbestos cases, plaintiffs put in their complaint that this quality of the water fluctuates over time. And they allege a 2018 batch that was bad.
Yeah.
But it's different. But they didn't join all the 2018 folks. And then they say there's a 2019 outbreak. But they didn't join all the 2019 folks. Instead, looks like they've strategically mixed and matched, and whether they did that strategically or they did that arbitrarily, that doesn't comport with Rule 1, where we talk about fairness, justice, and speediness. So what we would like is logical joinder, and Myles Hunwardsen's not logically joined here, because he sticks out like a sore thumb, being the sole 2019 plaintiff. And Miriam Brody sticks out like a sore thumb. She's the sole 2018 plaintiff, and she should be severed from this claim.
Okay.
Thank you.
Thank you. Okay. If you all had asked for my inclination was to grant the motion to sever. Realistically, you got too many different dates. You've already got 12 different complaints, so it's not an issue of all of a sudden you're breaking someone off a very large case. It's not like a construction defect case where people all live in homes in the same complex. Yes, you may know I'm one of the Chapter 40 judges, I'm one of the CD judges, but go ahead, counsel.
Well,
I can have questions on the 2020 batch, the other batches that are not 2020, difference in the home delivery versus the purchasing at various areas, but go ahead.
sure, I'm happy to address that. So let me give you a little background information on the case.
I don't need the background because I have a lot of people patiently waiting. It's a motion, right, to dismiss or motion to sever. I'm very familiar with the case. Go ahead.
The facts related to the October 2020 super bad batch are what alerted us to the problem. A large number of people got sick off that, and we have specific information and evidence as to why. And they revealed the connection between real water and these toxic liver injuries.
Okay, so let's go to the heart of it. Why these grouping in this particular case? These 5 individuals for different time frames with different ways where they purchased it. And Nevada Beverage was not part of the coordination, right? They didn't step to the coordinate in this case at that time.
Well, Your Honor, I'll tell you the exact reason for the groupings. Because when we filed the complaint, these are the plaintiffs that we had their claims ready to go. So what Rule 20 provides is persons may be joined, permissive joinder, at our discretion if they have claims or rights to relief arising out of the same transaction or occurrence or series of transactions or occurrences. That's the plain language of the rule, series of transactions or occurrences. And what Mr. Dodrill mentions is if I go in and buy a bottle of water at Costco, and then a month later someone else goes in and buys it from Terrible Herbs, those are different transactions. Well, yes, but they're part of the same series of transactions. What this case is about, what all these cases and claims are about, are the purchase and consumption of toxic real water. So if people purchased real water, consumed real water, and got sick from real water, we allege claims related to that series of transactions or occurrences.
Do you understand your stipulation, right, for coordination doesn't exactly say what you're saying, right? Because you all affirmatively gave reasons why it should be coordinated, not consolidated in front of Judge Alf, and why there was a need to have separate trials, right? Do I not need to take that into account because it's filed in this specific case, right? So it's law of the case a part of the reasoning. Don't I have to take that into account for the motion to sever?
I respectfully suggest that you should take the coordination order in consideration, but I think the court is not accurate about what the purpose and intent of it was.
I'm not saying purpose. I'm looking in plain language. I'm not looking at purpose and intent because I can't get into people's minds. I can't read people's minds. I can read plain language.
Exactly. The plain language of that doesn't say individual plaintiffs should get different trials. They say consolidation is impractical and not efficient because that would mean one trial with 60-something individual plaintiffs as part of it. So what we said was we got to have the judges keep the trials in the individual cases, which is why we grouped them together for efficiency. So rather than having 60 different individual trials involving individual plaintiffs, we're having a lot fewer based on groupings that were grouped together based on timing. 4, 5, 6 plaintiffs grouped together, which is a manageable trial to have individually versus the impractical trial of 60 individual plaintiffs in one consolidated case. So that's why we coordinated as opposed to consolidated. That's why the individual cases remain before the assigned trial judge for trial. So that there's flexibility in scheduling if Your Honor was discussing a potentially 5 to 6 month opioid trial next April. If the court is unavailable to try one of the cases in this department, we have other individual cases that are available to go to trial in other departments. That's part of the efficiency. That's exactly what the coordination order provides. So severing 2 individual plaintiffs in this case, all that's doing is creating another trial where there's really no efficiency reason for it. There's no suggestion that there's no logical basis to say that these plaintiffs are improperly joined. I mean, there's no case law, no legal authority cited whatsoever in any of the briefing. We pointed that out in the opposition saying, hey, the law says you can do this. It's permissive joinder. It's properly joined in these types of cases. The distributor does not make them different, doesn't require a separate trial. We said that in the opposition. Even in the reply, they can't cite a single case where a court said, oh, well, this is a product liability case involving joined plaintiffs under Rule 20, but one plaintiff bought from this store and one plaintiff bought the product from another store, so they should be severed. They can't try their cases together. That's not a permissive joinder. There's no case law that says that. It's the opposite. We cited extensive case law that demonstrates that exact proposition is allowed. So I'll just go back to the rule, because I know this court likes the plain language of the rule. The rule says persons may be joined in one action as plaintiffs if they assert joint relief as part of the same series of transactions or occurrences, and any question of law or fact common to all plaintiffs will arise in the action. Well, that is the case. It's series of transactions or occurrences, common law and questions of fact, which is exactly what the every coordination order says, including the orders from this department. And then the case law supports it. Under the rules, the impulse is toward entertaining the broadest possible scope of action consistent with fairness to the parties. Joinder of claims, parties, and remedies is strongly encouraged. That's the Ninth Circuit, 1977. Quoting the U.S. Supreme Court saying, Rule 20 must be considered liberally in order to promote trial convenience and to expedite the final determination of disputes, thereby preventing multiple lawsuits. Preventing multiple lawsuits. That's what we did. This is a large case. We tried our best to consolidate reasonable amounts of plaintiffs together for efficiency purposes, for the quickest and most expeditious resolution of the multiple lawsuits. And there's no basis to sever these plaintiffs over that reason. It's not in compliance with the rule or the policy rationale behind the rule. So with that, Your Honor, we would ask that the motion just be denied outright.
Counsel, just so you're clear, the court was reading directly from you all's stipulation. Paragraph 6. Although they involve separate and distinct plaintiffs, individual personal injuries, and some unique defendants, the real water cases all arise out of similar factual circumstances, and pre-trial discovery will involve common questions of law and fact. Right? So then it says coordinating or consolidating the real at this time for anything more than pre-trial discovery purposes, this is paragraph 8 now, will not promote judicial efficiency or avoid costs. A joint trial with more than 40 individual plaintiffs is not practical, and keeping the cases in their assigned judicial departments for purposes of trial scheduling, trial-related, or other case-specific matters is more efficient and lessens the burden on any one judge. Okay, so I'm reading from the one in Wren, but that same language is in a lot of them. It was quicker to find that original one. So that's what the court was saying. You all's stipulation specifically says that the common issues, that's why it's pre-trial discovery only. That's all I was quoting straight from you all's stipulation, counsel. I wasn't misreading or missaying, and I wasn't saying individual plaintiffs. It was right there from your own stip. Let me make it final word, okay? So.
Well, I just wanted to apologize if I was confused, because I agree that that's what it says, obviously. And what I was just trying to clarify was the 6 and 7 were the paragraphs saying, hey, these are all the same series of transactions, common questions of law, which is why they should be coordinated for discovery. But the next paragraph, what the intent was to say, for efficiency purposes, which is the policy rationale for the rule, it doesn't make sense to consolidate them all for one trial because it's impractical. So I apologize
No worries. I appreciate the clarification. Thank you so very much.
Thank you.
Counsel, you get last brief final word as people are patiently waiting.
Thank you, Your Honor. I do object to what plaintiff's counsel said. On page 8 of our moving papers, we cited the ACAB versus Murray case, 501 Pacific 3rd, 961. It cites the Parchman case, which comes out of the Sixth Circuit, and it provides 5 factors. One of them is whether the claims arise out of the same transaction or occurrence. We talked about that, and I did not state that it's a different transaction or occurrence if someone buys at one store and someone else buys at another store a month later. Again, I got 6 plaintiffs suing my client in 4 different cases. If all 6 of those plaintiffs were in the same action,
in this case,
right? I know, but if those 6 plaintiffs were all suing my client in the same complaint, I'd have a harder time moving to sever. And that's not the case, like Your Honor mentioned, and that's why we filed this. Common questions of law or fact. Obviously, the 2018 is much different than 2020. Miriam Brody, having filed suit more than 2 years after she allegedly got sick, raises statute of limitations issues that may not apply to some of the 2020 folks. Judicial economy is not going to trump fairness and justice and prejudice, which is number 4. Prejudice would be avoided, and that's what we're trying to do here is get a fair litigation and a fair trial for Nevada Beverage, and then obviously different witnesses and documentary proof. Ms. Brody specifically and Mr. Hunwardsen all had different doctors, different ailments, and that's going to be different things. So unless the court has questions on the motion to sever.
Why not an NRCP 20B? Right? Why can't the court just issue the appropriate orders under 20B? Why does it need to be severed? That's why I was waiting till the end to hear all the argument.
No, that's fine, Your Honor. I brought, I believe, Rule 21 with me. I did not print Rule 20, so I apologize.
No worries. NRCP 20, right? B, protective measures. The court may issue orders, dash, including an order for separate trials, dash, to protect a party against embarrassment, delay, expense, or other prejudice that arises from including a person against whom the party asserts no claim and who asserts no claim against the party. It seems to me what you're really requesting in this motion, I mean, you call it sever, but sever really means it's misjoined, but couldn't the court just do 20B and do the separate trial against your, right? Orders, separate trial against your client?
We could, Your Honor. We could have also moved, and we mentioned.
No, I'm just asking why does it need to be severed versus having
right,
protective
Your Honor.
orders under 20?
It ties in, and I know we haven't. You're compartmentalizing the motions, which is fine.
They are separate motions. The court
Correct.
does
I
have to
understand
do
that, and it feeds into the reason why we want to move to strike. Some of those allegations, most of the allegations, if not all of them, we want to strike. Plaintiff's going to want to keep in for his 2020 plaintiffs, because maybe some of that stuff is relevant and perhaps not inflammatory there. So looking at the rules, it made more sense to sever us because the 2020 allegations could then be stricken from the complaint, whereas, and because none of the other defendants have spoken to that, I don't know what their positions are, but it might be easier for the court to sever so that those 2020 allegations can be stricken from the severed claims, whereas plaintiffs and perhaps some of the defendants may not object to having those allegations remain in the non-severed portion.
Okay. I appreciate it. Thank you so much. Here's the court's ruling. Okay. I have to look at how the motion is filed before the court, right? So the motion was filed as a motion to strike plaintiff's second amended complaint. That's going to be denied without prejudice. The court doesn't see that there's a basis to strike under the various assertions alleged. Realistically, the motion really is more of a motion to sever claims. So now we'll deal with the second motion. The second motion is motion to sever claims against Nevada Beverage. And realistically, when the court looks at an NRCP, right, 21, it really goes to well, 21 says misjoinder, non-joinder. Misjoinder's not a ground for dismissing an action on motion or its own. The court may at any time on just terms add or drop a party. The court may also sever any claim against the party. Realistically, the court doesn't see that this is severing a claim against the party. Now that I've had the benefit of hearing your oral argument, asking some of the questions as well, the court really is seeing that Nevada Beverage doesn't want to be grouped in with the rest of the parties when it comes to certain things that may be in front of a jury or for certain type of decisions. Realistically, I don't see that as why a claim should be severed against Nevada Beverage. What the court really sees is that the joinder, at least at this very early stage, that's why it's without prejudice, the joinder, the court doesn't see that the joinder in itself is inappropriate. Once again, I'm looking at the standard of what I have, right, and how the early stage of this case is presented. It's not showing that anybody's, I've got allegations only, right, and I've got some time frame and allegations is all the court really has at this juncture. So what I see is really that the court can address most of the concerns if needed, if provided to the court. Court in no way encouraging, discouraging, or taking any opinion as to any motions that may or may not be filed before it. Realistically is that NRCP 20B gives this court the ability to do orders to address if there's aspects that is needed to be addressed to address a particular party. The court really doesn't see either A, that the motion to strike would be appropriate in the body of what it is, because it's not that those assertions themselves should be stricken. The assertion really is that they're not applicable or would be prejudicial to a particular party. So I don't see a basis on a motion to strike. Looking at a standard motion to strike and a case law supporting. So motion to strike, like I said, is denied without prejudice. So then we look at the motion to sever. When I'm seeing the sever, remember the severing is of claims, okay? Claims against a party. I really don't see that the briefing has really clearly asserted what is the claim. There's allegations that form the general allegations that form the underlying claims, but I'm not seeing, you know what I mean? Don't have any of the tainted water. We don't have a breach of warranty or whichever of the various, I think, 6 causes of action. I believe it's 6. I'm within 1. how that was argued to this court, that it would be appropriate to sever a claim as the party. So the court's going to deny the motion to sever without prejudice at this juncture based on what the court has currently been provided in the pleadings. The court takes no position if down the road it may need to do something under NRCP 20B. And that's not part of an order, that's just saying realistically I'm not taking a position on something that's not before me. So that's the ruling of the court. It is so ordered. I want to thank the parties. Is there anything else? That means since I have denied both the motions without prejudice, that means counsel for the non-movement would be preparing the order for case 831543, circulating it to opposing counsels. If any counsels who are on the case that were not subject to today's pending motion, I just ask that you circulate to everyone, and people can just tell you that they're either don't need to sign or if they're waiving signatures, just so the court doesn't have to go back and check to see if somebody wanted to sign it or not. And provided to the DC 31 inbox, of course, with EDCR 7.21 and the administrative orders. And thank you all for your time and your patience. And so we need to move on. Thank you so very much.
Your Honor, I apologize. One clarification. With the order, would it be okay if I run it by Nevada Beverage Council to approve as to form and content, and I'll email it to all other council and ask if they have any objections to it, but not require their signatures?
You need to have them give them a date that at least says, look, if I don't hear a response from you by blank date, I'm providing it to the court in accordance with EDCR 7.21, right?
Fair enough.
Is everyone okay who's not a party to this case that your silence is going to be acquiescence? As long as you're given like at least a day to review the order? Anybody object to that? Speak now, please. Well, I'm taking silence as acquiescence because everyone's remote or here in court and nobody said anything and we gave you a chance. So, yeah, we just need to make sure everyone's had an opportunity so we don't.
I understand. I will circulate it. I just,
Okay.
getting the signatures can be a
Right, but if people can easily, on an email response, say either waive or you've given them 2 days. If not, you're going to do it pursuant to what you said in court, as long as it's at least, 2
I will.
judicial days. I
thank
appreciate
you.
it, but if
Thank you for your time.
counsel on the movement wants more time, then that's a different issue. They get more time, right, because it's their motion. I appreciate it. Thanks very much. Okay, moving on to